from Houston, Texas. Reddy Neumann PC does bring in immigration updates every week, Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today? It seems that we are in a transition in the administration where, Trump administration is leaving and we have the new administration coming, but it doesn't seem that Trump administration is, he's still trying to damage the things. He did pass an executive order, he extended the executive order which was issued until March 31st. Any other damages coming, Emily?
Well, we have the potential for other damage with the H-1B cap registration process regulation that has already been proposed. We already submitted comments on it. This is the regulation that would change how the lottery is conducted and go by wage level rather than just random lottery. So that's something that potentially could be finalized and issued by January 20th.
How about any of the student visas where?
Yeah, same there. We have the duration of status. The proposed regulation would end that option and give each student a specific end date. So now you have to file an extension of your F1 in order to change schools or change programs, to file your OPT and get your STEM extension. So that is also something that could be finalized by the Trump administration before he leaves office.
Okay. Emily, what's going on this scammers? It seems that they're getting very nosy, and I see that a lot of these scammers pretending that they are the police officers, they are different kinds of people, and they're trying to get the money from the American citizens. Now they seems to be targeting specifically immigrants. And then when they are targeting the immigrants, Emily, what I noticed is that they have more details of these people when they're targeting though. They have specific letters issued from the different government agencies, fake government agencies, not the real, and they have specific information they're targeting. What do you advise clients when they get some contact and they get scared? And have had people who have spent $100,000 up to $100,000. They paid to these scammers.
Mm-hmm. Yeah, I think the first thing is to just assess whatever it is you're receiving. Some of these clients were contacted by email or received a letter as an attachment in an email, basically saying that you've violated some kind of immigration rule or Labor Department rule and you owe money because of it. So certainly don't pay any money until you get that checked out. Take a look at the email address that you're receiving this from. Take a look at the agency name that you're receiving this from. In the case I've seen, the agency that was not the proper name of the government agency that they were sending it from. Look at there's typos in the letters. They might have the name of the government agency, which should be in all, each word should be capitalized, and they would only have the first word capitalized and the rest of it isn't, or there'd be an extra space or a period in the wrong place. So certainly, if you're in that situation where you've received something asking you or telling you that you owe money because of some kind of violation, get it checked out with an attorney would be the best suggestion. Don't pay anything right away. Do some digging on your own. Take a look at where you're receiving this from before you take any action.
I put a link out there. His name is Khashoggi. I love this guy. He's very good. He eats the brain of the scammers. And I put a link of this guy's YouTube channel. I want you to watch it. It's really funny. He volunteers to take all the calls from the scammers, and he spends. I've seen him spending like 8 hours, 10 hours. That's his main job, and he gets money through YouTube views, and he eats the time of the scammers and really frustrates them to an extent where they go crazy and leave their jobs. I want you to watch the YouTube of it. I put a link out there. Whenever they're asking you for the credit card information, no government agency will call and ask you for credit card information. And they're threatening you that, okay, if you don't pay the money, you're going to get arrested soon. The arrest warrant comes in soon. Most probably, 99.999% of the time. I don't know of any 0.1% of the time that I can think about. It most probably is a fake thing. Please also watch for the accent that they speak. Most of these things are coming, unfortunately, from the country where We all are born. That is very unfortunate that this thing happening from there. Seems to be coming from India also, but there are other countries that, I notice that calls are coming. Be watchful on these people and try to speak when they try to knock you out, saying that don't speak with your friend, don't speak with any of your family members. This is something that we are going to we are going to arrest you within like 30 minutes. I mean, your things are going to be disconnected. Your social security is going to be disabled. Your electricity is going to be disabled. In 30 minutes, it's going to happen unless you pay. Please be watchful about these things. Try to speak. Don't try to be on the phone with them all the time. Try to speak with your friends. Try to be with your family, and it will make sense for you. Things will wait. I mean, if they don't want to wait, if any of the government officials really want to arrest you, though, most probably they're not going to call you and tell you that they're coming to arrest you. They'll just come and arrest you. I don't think so. You have done anything bad that makes you, but be careful of these scammers. One of the audience, Ashok Kumar, is pointing out Jim Browning channel. Oh, absolutely, I love Jim Browning. Thanks for mentioning about him. This guy goes after the scammers. I want you to watch his channel too on the YouTube. Absolutely the best guy, so that you can get educated what these guys are trying to do. Spend about half an hour on these channels at least right now, and then you will get a picture. When you get it, when your friends get it, then you will know what's going to happen though. The problem with these victims of these crime is they feel so insulted that they got into this trap, Emily, and they don't want to come out and mention it. Their money is gone anyway, at least that's what they feel, and by telling to the other people, they feel that, oops, what a buffoon I am. And that's where they are. What we are here to tell is that, yes, these things happen, and even if it happens with your close family, friends, and they're not speaking with you because they feel insulted that they become a buffoon. They don't want to become a buffoon in front of you. So that's the reason why they don't speak out, and we want to mention it to you so that you're aware of this. Emily, on the executive order that has been extended until March 31st, can you explain who are affected by this executive order?
Yeah, so it's continuing the existing executive order. So H-1B and L-1 visa applicants who are stuck outside the U.S., honestly, this order is not doing a lot of damage for the most part, because the consulates aren't giving the visas anyways. They're not operating to be able to give the visas. So people are mostly stuck because of lack of action on the consulate, not because of this executive order. There are some people that certainly are subject to it and are not able to get the visa if the consulates were operating at 100%, but they're not, and it doesn't look like they're getting to that anytime soon. They just updated at the Department of State their information about the resumption of visa services at consulates, just saying it's going to be a case-by-case basis based on the location. They can't give any specific dates, but they extended the validity of that MRV fee that people paid all the way through September. So that gives you an idea that these delays are going to be continuing. Even if the executive order is lifted.
What are the probabilities that the new administration will come and lift the executive order immediately?
I think that's probably going to happen very quickly. I think that's going to be one of the first things he does.
I also noticed some of the appointments that were recently been given, especially in the U.S. consulates in India in the last week of January. So be watchful about these appointments that have been given. If you fall into the category where you will be affected by the executive order, you may not want to go there for the interview until the executive order has been lifted. So please be watchful. There are some openings that were been opened up in the January last week. We don't know if they're going to honor those things, but if they do honor, I want to make sure that you don't come into the executive order. If you do come, you have to make sure the executive order has been lifted.
All right. What are you seeing in terms of processing times? Where are the biggest delays right now?
You mean to say processing times of the consulates?
In just USCIS processing and receipt notices.
USCIS in receipt notices. Emily, right now, especially for the adjustment of status, they are about in the October 3rd week to 4th week, somewhere around that right now. There are a lot of cases. I did the calculation today. The cases that were filed in the last 2 weeks of October, they haven't issued the receipt notices for almost, I would say about half the people. They have not issued the receipt notices. So, although I have noticed that, Emily, that there are checks that were being cashed recently. In the past 2 days, I mean, on December 31st and January 4th, a lot of checks have been cashed. I would say at least 10 to 15% of the cases that were being filed in that period of time got cashed right now. So there is some progress in there, but still, they haven't yet touched October 30th, though. They are somewhere between October 21st and October 28th. There are some people whose application were being received by the Texas address, the 485, that we received on October 28th. They received the receipt notice, but the other people did not receive. That's a big problem. And some of the people who have received the receipt notice assembly, they even got their biometrics. And then you have other people who haven't received the receipt notices. It's a nightmare. But we do expect that most of these things should be cleared pretty soon. Also, I noticed, Emily, is that the EAD and advance parole that were being filed in November and even December, we have noticed that they are issuing receipt notices, but not for the adjustment of status that were being filed in the last 2 weeks of the October. Seems that they pushed this entire boxes and they're opening. One of the reason is that when they open the boxes, though, there are only certain people that know how to process the adjustment of status applications. So for the people who are opening the boxes that are for EAD and AP alone, they are different people. For the adjustment of status, they are different people. That's the estimate that I have. That's the reason why there is a significant delay in the adjustment of status applications. And also, most of the applications were being filed, especially the downgrade applications, were being filed in the last 2 weeks of October. Though a lot of people waited to see the mail room clutter has been cleared. They filed it in the last 2 weeks. So they're starting opening right now. We should be getting the receipt notices pretty soon.
So if we're seeing this much delay in just getting receipt notices, we're already October, November, December, January. We're into our 4th month of the 12-month period for these, green cards, employment-based green cards for this year's quota. What do you expect is going to happen with all these green cards that go away on October 1st of 2021?
Yeah, very, very dangerous situation. I want to explain what Emily was pointing out is that there are 140,000 green cards allocated to the employment-based. We have approximately around 100,000 that were being not used by the family immigration due to the travel ban and COVID, and that fell into the employment-based. So we have all these 240 to 250,000 green cards available. If they don't give the green cards to the people, though, what will happen is that these green cards will not move to the next year. No. Only the unused family-based green cards will be coming into the employment-based. The employment-based unused green cards, where do they go? If they don't use it, they will go in the trash. We've been contacted by many people to file the court litigation. We're exploring the possibility for that, and we'll come up with a plan pretty soon about it. But it takes a little bit while because there are some legal challenges. How can you go after the USCIS when they haven't done wrong yet? We know they are going to do it, but there is no evidence that they are going to do it. We can't prove it that they are going to do it. So we may have to file some Freedom of Information Act to see what their policy is and try to go behind to see if there is any loopholes in the information that they have and try to file a lawsuit. So we are considering it. We have been contacted by many different people. We are working on it. We will keep updating on that.
All right. Also, we have, it's a new year, which means H-1B cap season is right around the corner.
H-1B cap is in March. Do I need to worry about it right now, Emily?
Yeah, absolutely. Now's the time to start preparing because, like last year, the actual registration process is earlier. So normally March was busy because we have to file everything April 1st through April 5th. Now we actually do the registration March 15th through March 31st. So if everything starts 2 weeks earlier, which means really you need to be getting your ducks in a row, getting your documents together so that your employer and their attorney can get that registration submitted in that short 2-week filing window.
Yeah, so please make sure that you prepare everything well in advance. Your employer is ready. The prevailing wage information is already pulled out. LC has been filed properly. And one thing is that we still are debating about whether or not this new administration is going to publish the regulations. Please be watching the new regulations. It is up to January 20th at 12 noon Eastern Time is when the administration changes. And before the administration changes, we don't know what this guy is going to do it. He can do anything. I mean, he can publish those regulations that may hamper the opportunity for you to get into the lottery system. So please come to our YouTube and Facebook Live so that you can participate, and we will give you the information if there are any changes. This channel that we have, I mean, if you come in, most probably covers all the things what a business immigration person who is a non-immigrant visa here need to know. And absolutely, you guys need to know these things. If you don't, it's very hard. You need to be aware of what's going on around. That's very important. So please keep coming back every week, and please, if you can, please put a like button or any comment button. We really appreciate all these things, what you're doing. Let's go to some of the questions on the YouTube. One of the gentlemen is telling that he has been a victim of the scammers, and he's going to speak with the other people. That's very good. Please, if you are the victim of any of the scammers, please speak with the people though, so that people are aware. A lot of people tend to be very shy on these scammers, and because of that, they don't get to, the society doesn't get to know. I mean, so please be speaking with about these scammers.
Rakesh from Facebook has a question about PERM processing times. Are there any delays right now? Yes, the PERM processing times are slowly getting longer and longer. Same thing with prevailing wage processing times. So you definitely need to plan in advance for that. If you're starting the process or thinking about it, make sure you leave yourself plenty of time so that you can get your PERM filed before you enter your 6th year of H-1B status. That allows you to continue to extend beyond the 6-year limit. Nowadays, it may not be possible to file the PERM in your 6th year and get the PERM and I-140 approved before you run out of time.
Question from YouTube, Madeline. She's asking, what are the challenges to move from H4 to H1B and vice versa? Well, from H4 EAD to H1B, assuming you're not being counted towards the cap, you have to go through the cap system. As Emily has pointed out, the only way to apply is between March 1st and March 20th through the lottery system. Once you get to the lottery system, you have to apply for a change of status from H4 EAD to H1B. Once you get the H1B approved though, if you want to do the vice versa, you want to change back to the H4, there are two processes. One, you can apply for the change of status again back to the H4, but there is another simpler, easier process. Since your H4 and EAD is still valid, you can do one thing. You can go outside the country, either to Mexico or Canada, and you can come back into the country using the H4. In that way, you don't have to go through the lengthier process of getting the H4 approval. It's called automatic revalidation. If you don't have the passport visa stamped on the H4, if you do have a passport visa stamped already H4, well, you don't have to go to Mexico and Canada. You can go to any other country and come back and move back to the H4. That's more easier way rather than filing a change of status from H1B to H4.
Sudarshan from YouTube has a question about I-94 numbers. His wife's current I-94 number on the I-539 is different than the I-94 on the website, and they recently filed adjustment of status, and the attorney advised to use the online number. Is that going to be an issue? So there's a couple of reasons why your I-94 number changes. The first one would generally be when you travel. So if you filed that I-539 and got your extension approved and it has an I-94 number on it, and then you travel, when you come back in, your I-94 number will change, and the one that's on the website, that's the most recently issued one, that's the correct number. That's the most common issue we see of people having different I-94 numbers, and then sometimes when they file their next extension, they accidentally use the old number instead of the new number that they received at the port of entry. I haven't really seen any problem at all with adjustment of status with having the numbers be different, as long as you have a I-94 that has not expired. The expiration date is more important than the number itself, but the number can create a problem sometimes for driver's license renewals if they're not able to verify the number in the SAVE system. So that would be the main issue that comes up, and you can really clear that up by traveling again.
Question that is coming from Vic from YouTube is biometric required for getting a green card EAD? No, that's not absolutely required though. You can get a EAD before biometrics. It is not linked with it, thankfully so. Another question from Balaji from Facebook is, does the ban affect the I-130 sibling application for F4 category? Balaji, the ban does not affect any of the applications you are filing with the USCIS. They will go through normally though. Now, if the I-130 is already approved, if the priority date is current, and they are supposed to go to the interview, that's a different issue. But the processing of the I-130 will not be effective. But one other bad news or good news, I don't know, depending on, there are certain circumstances, delay might be good for I-130, is that the I-130 application process assembly for the F4 category is approximately around 7 years. That's in some service centers. I'm actually understating, it's almost like 10 years in some of the service centers. That's so bad. So, but yeah, the processing is not getting affected for the F4 category. You should be getting the I-130 approved.
Pratyusha from Facebook has a question about automatic revalidation that you spoke about a little bit ago. Her I-94 is expiring in less than 2 months, and the visa stamp as well, but she already has the I-797 approved that extends the current status until next year, and wants to know, am I eligible for automatic revalidation? So yes, that's exactly what it's for, is if your visa stamp that's in your passport has expired, but you have a new approval notice that has an I-94 on it that extends your status beyond that visa validity, you can exit, go to Canada or Mexico only for less than 30 days, don't apply for a visa there, and you can use your expired visa to come back by showing your new approval notice that has a valid I-94 on it. It's called automatic revalidation, meaning that at the time of entry, they're going to take a magic wand and pretend that your visa that's stamped in your passport is valid automatically on that day, just for that moment to allow you to enter, and then it goes back to being expired.
Arun Kumar has this. He wants to see if he can file a lawsuit on the age-out kids, and he's willing to pay. Unfortunately, Arun, the legal basis for the age-out kids does not exist because it comes from the Congress, though. So it is not something that can be resolved by a lawsuit. Unfortunately, that cannot be done. What we are contemplating is the delay of the adjustment of status in the way that they are moving the priority dates. Yes, that is what we are considering. Litigation definitely for a lawsuit just for the aging out kids. It is not, according to us, it's not possible legally. I mean, it is mandated by the Congress, so that is the parliament of this country. It is not going to be likely any chance of success at all if we do that.
Monica from Facebook has an issue with her OPT STEM extension application. As you know, they have a very strict deadline. You have to get your extension application filed for the OPT STEM before your current OPT expires. For whatever reason, she's expecting that the one she already filed is going to be rejected due to a problem with the filing fee check, and wants to know if she should wait and see, or submit a new application without knowing what's going on with the other application. Yeah, I would recommend filing another application so that you don't miss that deadline, because it's very possible that you might not get the rejection back until after your current OPT expires, and then you've lost your chance. When you're doing that though, when you're resubmitting, make sure that your I-20 was issued within 30 days of filing the new application. A lot of times people aren't aware of that, and they just simply take the package and re-prepare everything they submitted before and just send it again. But if your I-20 has expired, that can cause the whole OPT application to be denied after they take your money. So be careful of that.
Prashant has some problem with the date of birth. Will it be okay if he gets an affidavit from the parents, family, and Prashant, yes, that should work. That should not be a problem. I have written article on rnlawgroup.com. Search it by birth affidavit. The format is there. There are some alternative documents that you can collect and keep it together. If I were you, I would just submit the affidavits. I would not do anything. When and if they issue an RFE, I will submit the additional documents. One more time, go to rnlawgroup.com, type in birth affidavits. I've given all the drafts, all the alternative documents that you need. Collect them, keep them, and you use them whenever they ask an RFE. Sonja has this question: how do we, from YouTube, how do we get in touch with you to speak one-on-one? We do have a link that is provided to you in this YouTube and Facebook, where you can make an appointment with me, Emily, or any of our 14 colleagues. That are very competitive people in our, they are very good, and we have categorized them which particular specialty they are in. You can book an appointment with any of us, and all the schedules of our colleagues are available online. It's there in the link, or you can go to rnlawgroup.com and you can go to appointments, and you will have all the schedules available of every lawyer that is there in our office.
Reethi from Facebook had an H4 and EAD renewal application pending and had to travel due to an emergency, got the H4 stamped and returned back to the U.S. while the H4 and EAD are still pending. Wants to know if this is going to have any impact on the EAD renewal that's been pending this whole time, and is it necessary to file a fresh EAD? So up until yesterday, I would say shouldn't have any issue at all. You shouldn't need to refile. Just let the H4 extension continue to be processed, and once it's approved, the EAD can be approved after that. However, we received an interesting outcome on one. This is just one case, but I want to just let people know to be aware of it. In this situation, same exact thing. Filed the H4 extension while it was pending, exited, got the visa stamp, and came back in. On the I-539 application, USCIS denied it.
Really?
Saying that they were administratively closing the application because we see that you've already traveled and gotten your H4, new H4 status through the time you requested. Now, that's not a problem for their status because they have the H4.
I'm worried about the EAD.
The EAD, could that be denied because the I-539 was technically denied? That would be my concern, and we've never had this problem.
But
ever.
Did you got the EAD denied or not yet?
We don't know yet.
Okay.
So that would be my only concern, is you may want to consider, and again, this was just one case. I've never seen that happen before. We don't know if this is a new policy. USCIS doesn't update us with new guidance before they do it. They just start doing things, and then we have to hurry up and try to figure out what to do. So you may want to consider filing another EAD. The cost is, the $410, but that may be worth it if the previous EAD ultimately gets denied and you've wasted all that time waiting. So yeah, I just want to mention that.
Sai Manoj has this question or a suggestion, I don't know. Trump administration has already banned H-1B entry to an extent, which you're right. Does he also has authority to stop the upcoming H-1B application process entirely for this year? Sai, no, he does not. If he does had it, he would have done it before. He does not have the authority at all to do banning the H-1B for the entire year. Had he had it, he would have done it for sure.
Karthik from YouTube has an interesting situation. He wants to know if there's ever a possibility of the H4 EAD being approved before the H4. His wife's I-765 case status changed to new card produced, but the I-539 is still in progress. I can say I've seen that happen once
I have
before.
seen once, very rarely, 1 in 1,000 times. But in this particular case, though, Emily, I think so he's just looking online. The online status of the H4 might not have been reflected properly.
Yeah,
that's the way I guess it. Yeah, there are rare scenarios where we have seen the EAD getting approved, but in this, mostly the H4 might have already been approved. Okay.
Macaronia from YouTube has a tough situation. Spouse's I-485 was rejected due to leaving an option blank on the form that's not relevant to derivatives. Can you refile in January in spite of priority date retrogression? So this is an ongoing issue. A lot of attorneys within the American Immigration Lawyers Association have been reporting these types of rejections where just based on how the form is filled out, that I-485 form is kind of confusing, and especially for derivatives, it's not entirely clear which box you should check when. And a lot of people have been filing their 485 forms the same way for, since the current version of the form came out, and then all of a sudden with these October filings, USCIS starts rejecting them, saying it wasn't filed properly. I believe this is something that the American Immigration Lawyers Association is trying to liaison with USCIS to get them to see that it technically was not filed improperly, that it's just a different way of interpreting the form. But unless USCIS provides some sort of mechanism for people that are in that situation to refile, generally the answer is no, you can't refile.
I think so that we can challenge them in the court, Emily. We have challenged USCIS in the court because they were rejecting some of the adjustment of status applications because any of the columns were being left blank. Now court gave a judgment saying that, hey, you can't do that. I think so we have a good chance to go and court litigate this issue though. If anybody has any of these rejections, if you're considering court litigation, we would like you to consult Stephen Brown. He's the litigation head in our office. The link is provided at rnlawgroup.com. The appointment list is there. Please consult him. He will discuss with you on the possibilities, because if they don't accept, you lose the entire, you miss the boat. You should contest this in the court and make sure that your application get accepted if for silly things that they just rejected. And it's not just a rejection. Had they rejected in the first 10 days, that would have been fine. We would have refiled it. Why did they took 2 months to reject it? So there is a good ground there where the court can give some relief for you, and which they have already given for us before on some other adjustment of status issues where people have left some information blank. Let's say they have 2 kids and the 3rd kid, they left it blank, saying that instead of not applicable, they left it blank, and they rejected the applications, and the court said, no, you can't reject those applications if they did it. So you can try to discuss these things, and maybe you should try to court litigate these things to get them accepting these applications.
Anoop from YouTube wants to know about the H4 premium processing. Is USCIS accepting that yet? Not yet. So we do have the legislation passed by Congress that instructed USCIS to allow premium processing for some new categories, including H4. That has to be actually implemented by USCIS. They're looking at their current processes and mechanisms and figuring out how to make that happen. So we'll probably be a few more months before we see that actually happen.
Shankar has this question: does entering on the advanced parole means I'm choosing EAD and giving up H1? The answer is yes. Once you use the advanced parole, then you are considered to be married to the adjustment of status application. That means that you're no longer on H1B, you are on EAD. I want you to go back to the video that we did presented in the month of October, where we discussed more about marriage to the adjustment of status application. In general, though, it's nothing bad. If your I-140 is approved and everything is clear, there's nothing wrong to be married to the adjustment of status. Just make sure that the I-140 is approved and you're good to go on that.
Srinivas from Facebook wants to know how long it's taking for an LCA filed with the Department of Labor website. He's got one that was filed December 10th and wants to know if it's delayed due to the holidays. No, it's not delayed due to the holidays. Something doesn't seem to be right there. We've not seen any kind of delay in LCA processing. They've been approved in 7 days very consistently, so something else is going on there.
Question from Kareem Baba. The question to Emily, but I'll answer it. What is a good time? Is it a good time right now to go for the embassy for H-1B stamping? No, this is not a good time. The reason is that even though you book an appointment, they're canceling the appointments very frequently. They have done in October, they have done in November, they have done in December. We don't know what they're going to do about the appointments. Even if they do open up sometimes, who knows? All of a sudden, we have seen England shut down again more rigidly because there's a different variant of COVID. So because of the medical situation, they have a good excuse now to cancel the appointment. So be very careful before you go for the embassy stamping. Even if you have an appointment, you can always cancel. You can always fly 2 days, 3 days before the appointment instead of traveling 1 week or 10 days ahead and then find out that your things get canceled. So please don't travel well in advance for sure.
Dinesh from Facebook wants to know if the consulates are processing B2 visas. Will they be open for that? So they technically are processing them because they're not subject to any specific travel ban or executive order, but the consulates are really only focusing on emergency appointments and F1 student visas. So if you are intending to travel on a B2 and need a visa stamp with an appointment, you have to have some sort of emergency situation as to why you need to come to the U.S. at this time. Otherwise, you won't be able to get an appointment.
Emily, I need some discussion on this one. The question comes from YouTube. Why aging out of the children should link to the final action date instead of filing dates?
Yeah, that's something that I think there's a potential for litigation because that is not anything that was determined by Congress. That was set in a policy memo by USCIS when they created the filing date chart. They just chose one or the other and said, we're going to go by the final action date in order to calculate age for the Child Status Protection Act. I don't remember there being any kind of commenting request or period for that.
It was not a regulation. It was not a regulation.
Yeah.
It was just a memo. They haven't given any opportunity for us. I think so. So going back to the comment, what we said, we don't have a possibility of litigation for the aging out. But in the cases where people have already filed the case, though, that's a good potential to look into if we can file a court litigation on it saying that, hey, they should be in there.
Yeah, I mean, what was the decision-making process of USCIS in deciding that that was the
No
way we were
notice
gonna
and comment
go?
was there.
Exactly.
No notice and comment was there. It was not a regulation. It was a memo. I think so. Sometimes this YouTube and Facebook, we get educated by you guys too. I mean, you're part of what our knowledge consists of. It's not, your feedback definitely challenges our intellectual thought. Definitely this Murai PK from YouTube, it's a good question. Why? No, there's nothing. When the law was being passed in 2001 or 2000, I remember, there was no filing dates and final action dates at that time. The final action dates and final filing dates came in 2015. And after that, this memo came out saying that the age out link is to go to the final action date. But yeah, that could be challenged. And I think so should be challenged. And I think so we will have enough resources. People will be funding us to challenge these things because it will cost money to challenge these things in the federal court. The US is not, CS, unlike the receipt notices, they give up in those cases more easily though. But these kind of policy kind of things, they will challenge us and it will be very expensive battle. But I think so we can divide it among the people there because that's going to be a good thing for us to take up, Emily.
Mm-hmm. Yeah, it would definitely help a lot of people. SNH from YouTube filed an I-140 downgrade in the last week of October and has received that receipt notice just recently and wants to know, is the processing time starts from the date the receipt notice is issued or the actual received date? So the processing time is determined based on the actual received date, not the later date of when you actually got the receipt notice. So that's good news. But I can guarantee you the current processing time that they're listing now is going to be longer 6 months from now based on all of these downgrade cases. So ultimately they're going to be increasing processing times to take into account that they really haven't been able to work on the cases during these 2 months of receipting.
Does the stimulus package affect getting the GC? No, absolutely not. This is the taxes that you paid, Girish. So no, that will not affect your green card. You're fine. It's part of the money that you already paid. They're giving it back to you. It's not like they're giving anything. This is not a food stamp or anything like that. Absolutely, it will not affect. Please take the money. Question that comes from D.I. Reddy from YouTube. Can I study Masters on H4? And if I do, will I be considered under advanced degree cap, 20K cap? Yes, you can. And you will be considered under advanced cap. Just a small note, it must be from an accredited university and non-profit university. Those are the two conditions that need to be met, accredited and non-profit. Most of them are, there are like only few that are not accredited or for profit, but I just want you to be careful about those two things. But otherwise, if you go to the normal non-profit higher education institution and accredited institution, you will not. You will be you will be going through the advanced degree cap under the 20K.
Jitin from Facebook has a PERM question. He wants to know if the job location changes without any change in job responsibilities, do I need to file the PERM again? Short answer is maybe. It all depends on what kind of position you were originally sponsored for and what they listed as the work location there. So let's give example A. You were hired to work for a company in Houston, Texas, and now the company is relocating to San Antonio, Texas, and your job is moving to San Antonio. That is going to require a new PERM because the labor market in San Antonio has not been tested. However, let's say that your company is based out of Houston, Texas, but your job is as a consultant going around from customer to customer to customer at any unanticipated locations. You never know from 1 month to the next which customer you're going to be at, and that was specified on your PERM form, the idea of consulting and third-party placement. They said on your PERM, this is going to be unanticipated locations, and at the time of filing the PERM, you were in New York, but now you're going to be in California. That should not require a new PERM because it was listed on your PERM that the job involved unanticipated locations, and now you've moved from one unanticipated location to another.
What are the next updates for the HR 1044 and Senate 386? Ram from Facebook. Right now, it's dead. Why? Because the Congress session was over on January 4th or 3rd, I forgot it. 2nd? 3rd. Yep. The Congress session was over on January 3rd, and now the new session comes in on after January 3rd. So the previous bills are all gone. Now they have to pass the new bills. We need to start our campaigning for sure. Is it the right time to do it? I will wait until January 20th, and then we should start a campaigning, contact the congressman at that point of time to explain to them that, hey, look, these are the things that are there. Take the discrimination off. Treat everybody equally, irrespective of their birth. That's exactly what we should be treating everybody. Don't judge the people based on their birth. Judge them by their character. And we should approach the Congress this time again with more enthusiasm that, Ram, we should all be judged not by where we are born. We should be judged by our characters in the employment-based skills, by the skill set that we have and the education that we have, not by the skin color, not where you are born, not how you look like, it's how your skill set is. We should start campaigning. I would rather say that starting from January 20th, we should, we should campaign, and from now onwards to January 20th, we should sharpen our tools and see where to approach, how to approach, and organize the things better. But yes, the existing HR 1044 and Senate 386 bill are dead. We need to start all over again from the ground level.
Tejasri from Facebook wants to discuss the challenges for converting from H4 to F1 and how to overcome them. The biggest challenge is the processing time, and this becomes an issue particularly for kids who are aging out, turning 21, where their H4 status is going to end and the F1 is still pending. So if that's the type of situation you're in, you have to do what's called a B2 bridge to bridge your non-immigrant status from H4 to the time the F1 is actually approved. Because what happens with the F1 with these long processing times is every semester the school is going to look to see, is your F1 status approved yet? And no, it's not. Okay, well, we're going to defer your program start date to the next semester. Well, now you have to show that your status will continue to the next semester. So if your H4 is aging out, you can't extend the H4 to next semester. You have to file a B2 to bridge that gap to the next semester. And that was only valid for 6 months. So when you get to the next semester and the F1 is still pending and your B2 is about to expire, you may have to file another B2 bridge all the way until you can get the F1 approved. That's the biggest hurdle. Other issues that can come up for kids who have been on H4 for a very long time, you have to prove non-immigrant intent, or you can't have immigrant intent when you are applying for an F1 status, yet these kids this is the only home they know. They don't have any real intention to go back to their home country, but the F1 requires you to have that intention. So I have not seen that be a reason for denial in these recent years with people aging out, but that's another thing that has to be considered.
With regards to the court litigation on the aging out kids, we're going to have a serious discussion in our office, guys, this week, and probably by next week we should be coming up with some plan. We will let you know on that, and we will have to, I know some of the kids who are aging out soon, so we will make them plaintiffs, and then probably the rest of the kids can join the court litigation. So yeah, that would be very ideal. We will discuss very seriously, look into what are the possibilities, which jurisdiction will be more ideal to file for us, and we'll look into that very seriously, and we'll disseminate that information to you in our next YouTube, or probably in an article on rnlawgroup.com.
Vijay from YouTube wants to know, if I don't get my renewal of my EAD in time, can I continue to work based on the receipt number even after the current one expires? It depends on the type of EAD you have. If you have an OPT EAD and you filed a STEM extension, yes, you can keep working for up to 180 days while your STEM extension is pending. If it's an AOS EAD, same thing. You can keep working based on the pending extension for up to 180 days. If it's an H4 EAD or an L2 EAD, no, you cannot. You have to stop work until you have the new EAD in your hand.
Kishore is asking this question from YouTube. I got the 485 receipt notice. Can I go for the medical test or wait for an RFE? I would wait for an RFE. Typically, they may issue an RFE, or they may just tell you to bring the medical test at the time when you come for the interview. If the final action dates are current, though, I may recommend you at that point of time to do an interfiling. It's called, use the word interfiling, and then file the medicals, though. But you don't know if the final action dates are going to be current right now or next 3 years. If the final action dates are not current, you file the medical, and every 2 years you have to keep on filing the medical. That's the reason I normally discourage people whose final action dates are not current to get the medical done. Also, please note that the adjustment of status processing time is about 40 months only. And that could be a big issue for us when we go consider the litigation with regards to the adjustment of status, not using the 250,000 green cards that we have. Siddharth from Facebook has this question. My wife is on H4 and he's based on his things. She's not on EAD, just a H4. Can she remotely work in India from US? The answer is, Siddharth, no. The governments at this point of time do not recognize cyberspace as a space. The only thing that they recognize, which I call it as where your butt sits, is where the jurisdiction comes in. If the butt is in USA, then you come under the USA jurisdiction. Since she doesn't have a work permit in United States, she cannot work. The vice versa, a lot of people ask this question, can I go to India and work in a US company? The answer at that point of time is yes. Do you need to have a work permit to work in USA while sitting in India? The answer is no, you don't need a work permit. Remember what I told you? Your butt is sitting in India. Since you are an Indian citizen, hopefully so, you have an authorization to work in India. So it doesn't matter where you work. So the governments don't have any restriction right now on where the cyberspace is, but it's where your butt sits. That's the way the government works.
Vamsi from YouTube says his friend's PERM was denied, and he wants to know what options he has and any idea why a PERM will be denied. There are probably 1,000 different reasons why a PERM could be denied. Simply checking one box differently or incorrectly can cause a denial. It's one of the most complicated types of employment-based immigration applications. So the reason for denial determines what options you have. There's an option of filing an appeal or a request for review that goes to BALCA, the Board of Alien Labor Certification Appeals. That takes years to process, but if you're successful, the original priority date stands, the labor is considered approved, and then you can move on to filing the I-140. If you do file an appeal, the employer cannot file another PERM for you for the same job. So you have to kind of do one or the other. Either start over, start advertising again because likely the ads have expired by now, do all the recruitment all over again, file again, or file the appeal, which may take years. Also depends on where you're at in your 6-year limit. That can be an issue. It may be better for you to file an appeal so that the application is considered to be pending. Once you hit 365 days of pending, then you're eligible to extend beyond the 6-year limit. So, you know, not enough information to be able to advise, but there are options, but it all depends on the reason for denial.
D from YouTube has this question. His PERM is approved. What are the probabilities of I-140 getting approval without an audit and RFE? Typically, D, the I-140 approval ratings are very, 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 very high. Very rarely, I mean, I don't want to say depends on, you know, that's me. Unless I see everything very closely, I would say the approval ratings are above 95% in I-140 applications. So very, very rarely we see any denials. And it's more than 95%. Very, very rarely we see any denials of the I-140. In general, though, we don't. 1 second. Emily, can you comment on the biometrics delays, what the USCIS plans are? I know you updated before.
Yes, so clearly they're delayed and they're going to continue to be delayed. They're only able to process about 10,400 biometrics appointments each day nationwide, and the backlog is currently at over 1 million, to where it's going to take about 125 days just to get through the backlog that's currently there. They do prioritize the biometrics based on case type. So from what we can tell, H4s, I-539s are at the bottom of the list for prioritization. Compare that to 485s.
I don't know why they expedited the 485 and the prior date is not current for them.
Exactly, yeah. So if you file the 485, the biometrics are starting to come for those. It really depends on your location, whether you're kind of in a locked down area or not, what the virus situation is. If it's an I-539, it could be months still before they get caught up.
Question from AF Virginia from YouTube. Kid is just turning 18, prior date is September 2011. has been filed downgrade application. What do you think the priority date will become current in the next 3 years? And should I consider getting married to this application using EAD? First thing, AF Virginia from YouTube, is that I have gone wrong 10,000 times in judging the priority date. I mean, believe me, there is nobody else in this face of this earth who has gone so much times wrong in predicting the priority date. I challenge if there is anybody. I have video evidence. I am the worst in predicting the priority date. Now, having said that, I don't want you to take any of the chances in your hand. I don't want you, I don't want your kid to get married to the adjustment of status. And you know the definition of marriage to the adjustment of status. Because if you get married to this adjustment of status, your kid loses H4. That means that kid is also on EAD. The problem then what happens is that if the kid final action date doesn't become current, the kid has to move to the F1 visa. Then if from the adjustment of status they can't move to the F1 visa. So don't get married, be watchful. Once the final action date becomes current though, now, then you are in a good shape. There are some exceptions that I have to point out to you though, that the period of time that the I-140 is pending, that period of time will be deducted from your kid's age. It may be worth for you to have a consultation with a competent lawyer to understand what are all the logics that are involved in it. Because you do have a 3-year, that's definitely, you know that, but also the time period that the I-140 is pending is also will be deducted from your kid's age. One thing I will suggest, which I tell everybody, to do premium processing for the I-140, but for you though, do not do premium processing, because that will be big danger. You can extend the age, you can deduct the age of your kid, so for the period of time that the I-140 is pending. For you particularly, getting an I-140 approval fast is not good at all. For the rest of the people whose kids are not aging out, I strongly recommend they should do premium processing. But for you, whose kids are nearby aging to 21, anybody who is more than 16 years old, I would say, who is in adjustment of status, your kids are, don't do I-140 premium processing.
Venkata from YouTube wants to know, can we refile a downgrade if USCIS returned it for some reason? I'm assuming that the petition was filed but got rejected. There's so many reasons they could reject for such silly little things. But yes, you can refile a downgrade at any time, but if the priority date is no longer current, you can't include the 485s along with it. So you can refile just the I-140.
D is asking question, does our office do labor and employment related cases? No. We only do immigration, of course, PERM labor, which is related to immigration. With regards to the employment related cases, no, our office is not proficient in it, not good at all in it. Please, we're not good. We don't handle those things.
Subankar from Facebook wants to know, will the spillover happen again in October of 2021? Well, based on where everything stands today, I do think it's highly likely that we'll get another spillover from the family-based categories this October. What might change that is if somehow all of these travel restrictions and travel bans and presidential proclamations are lifted and consulates are able to hurry up and process a bunch of family-based immigration, then that may reduce the number of green cards that spill over. The other potential is Congress. They could pass a bill that eliminates that provision for this year. That is something that kind of was tossed about in one, I think it was in one of the stimulus bills or one of the areas that Congress was looking at. They were considering stopping that spillover from happening to allow the family-based category to keep those green cards for the following year. So if they do something like that, then that would eliminate the spillover for this year.
Thanks. It's time, Emily.
Oh, yeah, it is. Thanks so much for joining us this week. Happy New Year to everyone. We hope you enjoyed our first Facebook and YouTube Live of 2021, and hopefully this year will be much better than last.
Yeah. Can't be any worse than 2020.
Don't say that. Oh, you better knock
Yeah.
on wood.
Thank you.
Good evening, everyone.